So let's start with where Lisa left off. And Judge, I'm going to come back to you. This idea that the defense is going to file a motion questioning the eligibility of Lindsay Halligan in her role. Does that sound like a strong approach or strategy for a defense lawyer to take?
It's an unusual one because we're rarely in such a position, but it is Pat Fitzgerald's duty. It's his job to, turn over every stone and look behind every door and make sure they make every argument. And if this is a viable one, he'll make it. It's hard to have any insight because U.S. attorneys are U.S. attorneys, and we don't run into this issue. We don't run into an issue where someone gets fired and then someone is put in, so quickly and somewhat surreptitiously into a position. But the real issue here is something a little bit different, which is this isn't necessarily about the trial or the process or whether Mr. Comey is guilty or not guilty and whether there's a trial. This is really about humiliation. It's getting him out there. It's having him in, cops and Kevlar jackets going to pick him up and that wish. And that's really what's troubling. But in terms of that motion, that will be determined. But I think Lisa Rubin was right that the indictment may still stand even if she doesn't. The fact that someone else didn't sign it may be more technical. But we'll find that out.
Rebecca, what do you make of what we learned about how the lawyers acknowledged in court these prosecution lawyers, that were brought in from the North Carolina we were discussing district. So they said they didn't see the case. They acknowledged how new this was to them. What does that suggest to you? And are you surprised even more so that they decided to join forces with this office?
Yes. So, you don't go into court, especially in a case like this, which, as we've said, it is very hard to prove a lying to Congress count. And that's because you have to show that this is an intentional falsehood. So to the extent that there's any wiggle room in the words that the individual said, that is a defense. And you need to show that there is no wiggle room, that this person intentionally lied, that they said something factual, and that fact is absolutely untrue, and they knew it to be untrue. That is extremely hard to prove. So when normally a case is put together, as Chris was noting earlier, the FBI or the investigators put this case together in a very careful way, bring this evidence to a prosecutor who himself or herself would review this evidence and make sure that they are behind it and then go into court. So it is extremely unusual that you would have a situation where the prosecutors assigned to this case say to themselves, like, we don't, this can happen. I was a state prosecutor. This can happen in state court where it's just like there's a lot of shuffle and back and forth. But in the federal system, it's very rare. And in a case like this, with a count like this, it's even rarer.
What do you think about the piece of the classified intelligence, Chris, and that being an issue for Comey's lawyers, being able to access and have the security clearances that are needed?
Well, they'll get it. Number one, they've had them before, so the court will order this. And I'm not quite sure how much classified information will have to be produced for this. The charge on its face is not something you would have a ton of classified information involved in. But while Eastern District is a rocket docket, I've been involved in trials there, counterterrorism trials that took years because of the classified nature of things. So it could complicate this, and really, as the judge was saying, January 5th is a date on the calendar, but it's really not realistic. So I think that's interesting. What I think is equally interesting is these AUSAs going in and telling judge, we don't really have all the details.
Right.
We're new to this. Having been in court and worked with tons of AUSAs over the years, I've never heard of that or seen it. Probably not what a judge wants to hear. I'll put it in the category, I arrested a bank robber when I was a very young agent, and the defense said that my client was drunk when he robbed the bank, so he shouldn't be held culpable. My jaw dropped, but this is really just about as impressive as that was. I just have never seen that before.